What's up, everybody? It's Jason Cruz with another edition of The Legal Submission. Big news. On Friday, September 24th, the Ninth Circuit Court of Appeals granted in part the appeal of former UFC fighter Mark Hunt regarding his lawsuit against Zuffa LLC. As you may recall, Mark Hunt had sued the UFC, Dana White, Brock Lesnar for the allegations that the UFC allowed Lesnar to be a doping fighter without any guardrails as far as him taking performance enhancing drugs, and as a result, he claimed damages from his loss at UFC 200. Now, that lawsuit was filed in federal court in Las Vegas, and on a motion to dismiss, the federal district in Las Vegas did away with the lawsuit, citing that Hunt had no claims regarding a breach of contract, regarding conspiracy claims related to RICO violations, civil RICO violations, and fraud and battery. Now, we are going to discuss several of these claims. He had a lot, but we'll focus on the key ones here. First and foremost, Hunt had claimed that the UFC breached his contract with him because he faced a fighter that was doping, Brock Lesnar. Now, you may recall that Lesnar was sort of a surprise combatant for UFC 200, and they wanted to keep that under wraps, and so he was not disclosed until like maybe a month before the event was going to transpire. Now, in that scenario, we heard in the pleadings in Hunt's lawsuit that Dana White had texted Hunt notifying him of the potential fight with Brock Lesnar and the fact that USADA would be testing Lesnar. Well, Hunt had argued that there was a breach of contract because the UFC did not hold up its end of the bargain, and he claimed damages related to this to the loss, but the trial court had determined that those damages, which were deemed consequential damages that did not directly flow from the breach of the contract, were not able to be claimed in a breach of contract claim. So essentially, Hunt's claim that there was a breach of contract would not go forward was dismissed because he lacked the actual damages. Appeals court sided with the trial court, saying, breach of contract is not going to go forward on that claim, just because of the damages Hunt had sought out and had shown the court were not related to the breach of contract claim. Now, he had wanted to do more discovery on this Hunt side to perhaps find some issue where they could gain some traction on that particular action, but that didn't come to pass. But what did come to pass was the issue related to the battery claim, and this is a big one because in this case, Hunt was claiming that he did not submit to having Lesnar, who was fighting with him, he did not submit to fighting a dope fighter. And so the argument began that, from the UFC's perspective, that Hunt had assumed the risk. Just like in every of the contracts that the UFC has, there's an assumption of the risk clause, which states that you can be injured, even possibly die in the octagon. And they signed up on that, and that happens. That is the case. It happens all the time. However, the theory that Hunt had was that he had agreed to fighting a guy who was not taking performance enhancing drugs. So therein lies the issue: is that, you know, a tort may have happened because he did not authorize to fight a guy who could have been using performance enhancing drugs to overpower him in some way. So the trial court did not make a factual finding as far as whether or not there was an issue related to Lesnar's actions. Now, they did say in their opinion that there was nothing unbecoming, unfit. There was nothing that stood out that Lesnar did during the fight which would presume that it was out of context, out of the realm of possibility of a particular fight. Now, I've talked about this before. There is a California State Supreme Court case, Avila versus Citrus Community College, I believe it's called. And that was the case that was cited in the trial court decision, which would dismiss Hunt's case under a motion to dismiss. So a motion to dismiss is pretrial discovery, and we'll talk about that in a second. So of the Avila case, just to refresh everybody's recollection, it was a baseball game, and the pitcher threw a beanball at the batter. The batter sustained injuries, very serious injuries, and sued the team and sued the district. And so, without going about how this all came out regarding who settled and who didn't, and the case went down to the per individual who was injured versus the school, the community district. And the California State Supreme Court indicated that a beanball, even though outside the realms of the rules of baseball, was not outside the realm of the rules of the traditions of baseball. So when we think about that, we think about, well, could a batter have assumed that somebody would hit him in the head or throw a baseball at a head, even though that's illegal? And so, using that footprint, the trial court in the Hunt case had dismissed Hunt's claims, citing the fact that even though Hunt did not sign up for a fight with a guy who was taking performance-enhancing drugs, there was nothing out of the ordinary in the actual fight which would indicate that the drugs would be assisting Lesnar, or Hunt was injured in any other way more extraordinary than if he was just to fight a guy who tested negative for performance-enhancing drugs. And that had become the issue that I thought that would overturn this particular case in Hunt's favor. The appeals court had asked questions of both parties related to this particular issue. There is nothing in the law. It's a novel issue. It's a very novel issue because what you have is a very niche area of law with tort liability tort liability within sport. So you have instances in which a player may go outside the bounds of sport. Say, in one of the more novel cases, Hackbart versus Cincinnati Bengals, a football player hits another football player in the back of the head on the football field. The football player that was injured eventually sues, but there was no liability on the part of the team of the person who struck the plaintiff in that case. There's the case of Rudy Tomjanovich, who you may recall was a Houston Rockets head coach, but before that he was a basketball player. Kermit Washington struck Tomjanovich, broke his jaw on court during a game. And in that case, actually, Tomjanovich won a civil lawsuit with respect to that. And now that's an actual punch. Then you got other issues. If you recall, last year, Cleveland Browns, Myles Garrett hit the Pittsburgh Steelers quarterback Rudolph with a helmet. Now, was that within outside the bounds and scope of the game of football? Certainly, things like that, bench clearing brawls in baseball, are if someone were to be hurt in those particular instances, is there civil tort liability on the offender, and does the person that gets injured have a claim against the individual that struck them, or the team, or even a greater theory regarding maybe a league has an issue? Now, in this case, again, there is a definite novel issue, because here Brock Lesnar was taking performance enhancing drugs. He tested positive for a drug that he shouldn't have. And the issue becomes, in a doping situation, is a dope fighter liable for battery if he injures a fighter? That's a hard issue, because how do you discern what percentage of the fight was related to his doping? Do you consider the whole percentage a battery? Do you consider 50%? How much did it help? What if the doping issue did not deal with a performance enhancing drug that would give you strength or would help you? What if it was just a drug that you were looking for to cut weight faster? Obviously, in this case, I believe it was not. It was a issue. It was a drug related to cycling of potential steroids. We don't know that for sure, but definitely that may have been a thing that could have happened. But basically, the court found, in a footnote, they indicated that in a footnote in the opinion by the Ninth Circuit, they note, even if the Supreme Court of Nevada were to conclude otherwise, dismissal of Hunt's battery claims would not be appropriate at the pleading stage. The California Supreme Court's application of assumption of the risk principles in Avila versus Citrus Community College District was predicated on a factual finding that intentional beating is within the range of ordinary baseball activity. Importantly, here's the big one. Here, there has been no similar conclusion that doping is within the normal scope of organized MMA activity, nor does the question appear to be beyond reasonable dispute. So that's the big issue with respect to Hunt's lawsuit and why the Ninth Circuit overturned it. It's a novel issue. It's a very interesting theory that Hunt put across. And the fact of the matter is, the issue was at the pleading stage. Now, for your lawyers, you might go back to civil procedure. For those that are not lawyers, this lawsuit was dismissed at a stage that was prior to discovery. When a lawsuit is filed, a defendant, the person who gets sued, has a certain amount of days to file a response. Either they could answer the lawsuit, either affirming or denying or saying that they don't have facts yet, or they could do something which happened here with the UFC, which is dismiss, bring a motion to dismiss for failure of facts. So basically, the UFC brought this motion to dismiss for failure to state a claim. For failure to state a claim based on the lack of factual information. Now, obviously, this issue comes to a head with respect to a factual determination. Is doping within the normal scope of organized MMA? Now that's you could have so many questions on that, but the question appears to be beyond reasonable dispute. it would seem as though here that there needs to be more discovery related to how Lesnar fell through the cracks of USADA testing. It's worthy to note that when the judges in the Ninth Circuit questioned Lesnar's attorney, that it was clear that there was no real quick turnaround prior to Lesnar's fight regarding testing his drug tests. If you had been following this, Lesnar drug test did not come up, and the previous the test prior to his fight did not come out until after his fight. And the last time I believe that Lesnar was tested for his, I believe, July 9th, 2016 fight, he wasn't tested. His last time he was tested was in June. Why? Why did this happen? Especially when Dana White and Mark Hunt were texting back and forth, and White promising Hunt that Lesnar would be tested. Very interesting issue. And so if we delve into a discovery issue, we might be finding out more. So what happens next? First and foremost, the UFC may think about appealing this decision. First and foremost, the UFC can appeal this decision. Whether they decide to or not, we are not sure. They could also just try to settle with Hunt. They don't want to. They probably don't want to get involved in a huge discovery issue and have some information that they don't want leaked out, that comes out in discovery. For Hunt, it's a great win. Even though it's not really a win, it's just basically they're sending it back to the trial court. It's a great win because he didn't back down from the UFC, and some of his allegations stuck. So his fraud claim with respect to the issue that he could have that Dana White gave him representations that Lesnar would be tested. That is an issue that still remains, and so his fraud claims remain. Also, his battery claim remains, and that's kind of the best and most interesting part of this case is that not only the fact that Lesnar was taking performance-enhancing drugs, that USADA noted his failed test, that Hunt brings up this claim, and it's a claim that we don't see that much or haven't seen at all, is with respect to the use of performance-enhancing drugs and a tort liability theory. It's a hard one, I think, for them to particularly win, but it forces the hand of the UFC to defend itself. I think that in the end we'll see a settlement of this case, but again, the theory of liability is very interesting, and it could force the UFC to provide documents that it probably doesn't want to with respect to why and how they tested Lesnar at this particular point in time. I would again reiterate that this case isn't over if the UFC doesn't decide to settle. They could still go through the discovery process and still apply a dismissal action, motion for summary judgment after discovery, citing that there's still no issues of fact there for the claims sought by Hunt. But it's still an interesting win, and you don't see this win by many fighters when they enter into lawsuits with an organization. So this is interesting case, and we'll continue to follow it. This is Jason Cruz with MMA Payout and the Legal Submission. Have a good one, folks.